Good morning, Ms. Tabashe. Good morning, everybody. I'm sorry,
Good morning,
we're starting
Chairman.
6 minutes late because of some urgent stuff I had to attend to. Are you ready?
Yes, I am, Chairman.
Okay. Good morning, Ms. Rockman.
Good morning, Chair.
Thank you. Okay, let's continue.
Thank you. Ms. Rockman, yesterday when we adjourned, we were discussing what provision had been made for the payment of the 114 million to Estina as an implementing agent over the 3-year period that this 114 per annum had to be paid. You are going to have a look at your documentation and just assist us in locating the form in which this allocation had been made for Estina. I just for convenience sake, I actually did the exercise last night, and I would point you to ER 43, which is in HH 13B at page 563. We've dealt with this letter before. So it's ER 43. It's part of your original submission. And I just actually thought that quite a few of the numbers are very well summarized in ER 43. In any event, for purposes of the record as well.
What page did you say it is?
It's page 563, Chairman.
Thank you.
Of the original bundle. But it's bundle B because it's an annex share, it's in bundle B.
Yes, I've got it.
And
Have you found it, Ms. Rockman? Not
Not
yet.
yet.
I think it's Exhibit HH13B on the spine.
apparently the 3 files that are on the table, yes.
I think you may have confused her by saying part of her original submission. I thought when you said that you meant the bundle which has got her main affidavit, which is A, not B. So maybe she got confused because of that.
Chairman, if those are
Have you found it?
I think so, 563.
Yes.
Yes, that's
It's annexure ER 43 at page 563.
Yes.
If those are the other bundles, you might want to bring them a little closer. I'm not sure if that's A and C that you left.
Yes.
I think just bring them a little closer to the extent that we might need them. Not too close, but at least they should be somewhere where you can reach them without having to get up.
Yeah, maybe her chair is too far away from
Those.
She might wish to bring it closer.
Thank
you.
you,
Do whatever makes you comfortable.
Yes, the other chairperson is used as storage already, so we'll manage. It's fine,
Okay,
thanks.
all right.
Thank you. And really at paragraph of 6 and 7 is what I just wanted to bring to your attention. That's ER 43, page 563, paragraph 6 and 7. As you speak to the issues, maybe you can just say that's a correct summary of what you're going to be dealing with. Then I also would like to, just before you start, point you to, in very specific terms, to paragraph 7 and confirm that the 12 million that's recorded in paragraph 7 was going to be drawn from the Mohuma Mobung allocation. Do you confirm that?
Yes, Chairperson, that's
Excellent.
correct.
Then what actually happened in practice is recorded in that paragraph 7 of ER 43. The next point, really, these are just points I'm making and just summarizing what I understood of your evidence yesterday. Smaller projects which were to be funded under the Mohuma Mobung allocation were sacrificed in order to fund the Vrede Dairy Farm project. Is that correct?
That's correct.
Thank you.
Chairperson.
So the 30 million that was paid to Estina on the 9th of July was drawn from the 35 million that had been allocated to Mohuma Mobung from the MTEF allocation of 2012-2013.
Yes, that's correct.
And this is actually just a link I'd like to make. When Ms. Anna Fourie was here, she told us that when the CFO of DARD approached her for the payment of the 30 million, she informed her that all that was left in the Provincial Revenue Fund was 5 million. And I'm really just trying to find out if the 5 million that Anna Fourie spoke of is the balance of this 30, or is it a totally different amount? That's the only, I'm just trying to understand the evidence.
No, I think Ms. Fourie would have made reference to the cash available in the Provincial Revenue Fund, not
Yes.
necessarily available for this project or agriculture.
Thanks, that clears it up for me, because then there's no link between the two. If there had been, I would have asked a couple of other questions.
There was clearly no cash available to accommodate a request from any department of over and above 5 million.
Yes, absolutely, thank you. Then if you look at page 565, there you have a breakdown of the budgets. I think I'm going to allow you now to, and I'm simply using ER 43 as a reference document.
Yes.
So where you think the recording is not correct, for instance, there's that table that tells us what was allocated, please assist and tell us to correct that document as well as you give us the correct figures. Simply because I think ER 43 is a very useful summary. Thank you.
Thank you, Chair. I think you indicated yesterday the information is almost split between, there's a part in the main affidavit and another part in the supplementary affidavit. But essentially for 2013-14, the funding was 53.950 from the Comprehensive Agricultural Support Grant, the CASP grant.
So under CASP,
there was 53.950.
there was 53, just over 53, correct?
Yeah. And then from infrastructure enhancement allocation, that's the provincial fund, it's 60 million. Then at the time, agriculture, fishery and forestries withheld the funding.
Yes.
24 million of that 53.9 was already spent. So they effectively withheld 29.950 million then. In the adjustment budget that year, we reduced agriculture's overall allocation with 10.962 million. Then there was a separate submission made by agriculture in December 2013.
Yes.
Which was then authorized for payment by HOD Treasury. And that funding was then appropriated in the Special Adjustment Appropriation Act. We provided for 25 million, which came from all other uncommitted funds at the time. And there was an internal reprioritization within the Department of Agriculture that made up that balance of
So just
4.9.
I beg your pardon. If you just repeat the last sentence, then I'll ask my question.
The 30 million that was authorized for payment in December 2013 by the HOD, it was then appropriated in the Special Adjustment Appropriation Act. The 4.950 million came from internal reprioritization in agriculture, and 25 million was additional funding that we took from all other uncommitted funds and made available in that Special Adjustment Appropriation Act.
Now, can I just understand this clearly? So the 25 million, you looked for it within the monies available to the Department of Agriculture and Rural Development?
All departments in the province, everyone who had unspent funds. That is our standard procedure come January, because in the first adjustment, in the first adjustment appropriation, departments are defensive, saying, no, we've committed the funds, you can't take our funds. So you give them the benefit of the doubt. Come January, we don't listen to anyone. If it's not committed on the system, your money goes. It's all treasuries unfortunately work like that.
That's fine, but at least we know that in December representations were made, they were considered, and you were able to find an additional 29.9,
Yes.
really 30 million.
Yeah.
Okay.
Yeah,
And this is in 2013, 2014.
yes.
So what were your totals that were available? Were you able to meet the 114 million for the financial year 2013-14?
I think more or less we did, yes.
The question I have is really related to the planning function of the department. They obviously did not have this money. They hadn't asked for it originally in the 2013-2014 allocation. And I just want to understand the regularity of waiting for people to scramble around in December of 2013 looking for money. How responsible is that of an accounting officer, or is the standard I'm setting too high? Does it happen in the normal course that people will be scrambling around to try and find money for somebody?
No. At the start of 2013-14, if you go back to the annual performance plan and the budget vote statement, they did provide for it. The CASP funding of that 53.950 and the 60 million, that would give you almost the 113 million that was required for their commitment.
I see.
The crisis came when DAF stopped the funding, and there was that shortfall of the 29.5. So they had no option but in adjustment to come back to us to ask, guys, we need to make up this shortfall because the CASP funding was withheld.
No, I'm satisfied. I think I now understand clearly what did happen. Can we then look at the next financial year, 2014-15?
Yes,
What provision was made?
from infrastructure enhancement allocation, we made provision for 35 million. That was in the budget vote statement. Then going towards the adjustment appropriation, there was 10 million in reprioritized funds and provincial owned revenue that was made available. Infrastructure enhancement allocation, we increased with that 10 million for farmer support, and veterinary services was decreased with 4 million. But further in the Special Adjustment Appropriation Act, we reduced the infrastructure enhancement allocation with a further 3.803 million.
So your short answer is provision was made, and it's the usual standard way of finding money that was applied even in 2014-15.
Yes, although it was short of the whatever commitment they had, what they had foreseen in the original agreement as structured.
No, say that again. I'm sorry, I didn't quite understand that.
Look, for example, if you use 113 million was the commitment for 2013-14,
Yeah.
we could only make 35 million available in the next financial year
Yes.
for 2014-15. So
Yes.
it was far short of, if it was supposed to be 113 million, it was far short of that.
Please stop there. This is precisely what I'm trying to understand, because I just have Section 38.2 in my mind. And Section 38.2 of the PFMA says, don't commit a department to a liability that you haven't provided for. And I think what we're teasing out now is, what does provided for mean in real terms? So if you know you're only going to have 35 million from a particular source of funding, does what the HOD signed up to on the 5th of June and then again on the 5th of July constitute providing for, as set out in Section 38.2?
Not at the point of the first signature of the contract that was then redone. But when Treasury signed off, ultimately, when they asked for that first 30 million and part of the conditions was the contract must be reviewed and so forth, I think the MEC signing off at that point fulfilled the requirements of the PFMA. The revenue fund was then committed.
Okay, that helps. That does help. I didn't really want to go all the way to 2018 because I was more interested in what might have happened up to the time that the agreement with Estina was cancelled. Unless there's something particularly important you want to bring to the chairman's attention in relation to the next few years, so 2015, 16, 16, 17, 17, 18, you may wish to do so if you really think it's important for the chairman to understand what was going on.
I think the details are set out in the affidavits and the annexures, except to say that at the time FTC was then appointed to take over the project, there's a portion that went to the settlement of Estina, but another portion then went to FTC for the ongoing project management of Vrede Dairy. But I think those details are set out.
One of the sections that I would like to cover this morning, however briefly, is the FTC appointment and monies that were paid to the FTC, particularly because it's an issue that's come up at the hearings. So when we get to that, you may find a space somewhere in those questions to elaborate on this particular point. Can I then go back to general questions? I've always wondered whether EXCO at any point, and especially if you attended those meetings, considered the fact that there were other projects that required funding, other dairy projects. So we know about the Kwakwa project, we know about the Sitsoto Dairy project, because those were mentioned in that submission to the Premier, the submission of the 28th of February. Did EXCO express a view at all on how those would be funded if all the Mahuma Mobung money was essentially being channeled to the Vrede Dairy project?
I think it was included in all of the department's presentations when we were doing the budget process, so it would have been flagged. But as much as we made provision for Mahuma Mobung then, initially it was set out that we would be supplementing from provincial funding, and Vrede Dairy would be brought into the conditional grant funding. When DAF stopped, I think the process reversed, that most of the other projects, other agricultural projects, was funded through CASP and Ilima Letsema, and our own funding focused on accommodating Vrede Dairy. So the other projects continued with the conditional grant funding.
Yes, I'll accept that and interrogate that with Mr. Tabata, because I'm not sure about the veracity of what you're saying, but that's fine. That's your information on the issue. I've often wondered as well why the Glen Agricultural College was not requested quite early on to assist at the Vrede Dairy Farm project, because it would have been a cost saving. And what they do at the Glen Agricultural College, I know in part, deals with what was happening at the Vrede Dairy Farm. Do you have a view on this?
No, I have no view.
That's fine. Then, a question the chairman has asked a couple of witnesses is, can anybody explain the urgency in getting this particular project off the ground in the 2012-2013 financial year, when monies had obviously not been properly set out or provided for this particular project? You deal with these matters at your paragraph 224, 2.2.4 to 2.2.13. So we are at volume A of your affidavit, page 17 to 22. And I'd like you to just speak to those points, but at the same time, if you could find, have you found those pages?
Yes.
Now, if you could also find reference bundle D, reference bundle D. It may just be one that's up at the top because it's a reference bundle, not an affidavit bundle. So it's reference bundle. So it's Exhibit HH, reference bundle D. And the pages that correlate to what you're about to deal with are pages 1364, 136, let me go slowly.
Yes, I'm there.
Are you there?
Yes.
So it's 1364, which is a letter by Mr. Moses expressing certain concerns. The next one is 1366, page 1366, which is the letter from Advocate Ditira, also expressing concerns. And the last one is the more important one of the three. It's a email from you to Mr. Beatrice Venter. That will be found at 1367. And I simply want, without going into the detail of these, want to say, if you look at the very last line on your email, you too seem to believe there's some urgency in getting this project off the ground. Can you just speak to these issues for us?
I think we need to go back to the State of the Province address of that year, February 2012. The project is announced. Then it's taken up in the provincial budget speech, there's reference to it. Then the budget speech of the department, there's reference to it. Now, that process concludes by March. So in the new financial year, you expect departments are beginning to implement. Now we come to June. Nothing has happened. So the first urgency is created in the EXCO decision to say, that was the meeting of 13 June 2012, the one that the resolution is ER7, where it says, we know now the budget provision that was made. We know what comes to EXCO was a request for 84 million. The resolution clearly says the matter must go to Treasury Committee as a matter of urgency. I'm then informed by Mr. Venter on 18 June, that's after the EXCO meeting, that he has received this request from Advocate Ditira. He was at the time on leave. They then see that, but there's already an agreement concluded. They have to look at it and advise. I then inform him, I've also been informed there's a Treasury Committee on the 19th of June, also on Vrede Dairy matter. Now, when I joined that Treasury Committee meeting, I had my own meeting as DG, so I wasn't there from the start. So I joined them later, so I'm not able to say what was the extent of the discussions. But at the time I joined, it became very clear to me that Treasury was not in possession of the documents that even the state law advisors had. They did not have enough information to make any kind of informed decision. And we then had to go through that process to say, let us, agriculture, make available information to all of us so that we can see what is it that you are talking about. Because you are taking us by surprise, but equally you are pressuring this thing must start being implemented. Our communication then with Mr. Venter is not the urgency to get the project implemented. It's the urgency to get finality on, can we get the framework documents in place so that we are able to report to the next EXCO? Can we resolve the matter or not? That was the urgency I was referring to him to. You would see that from the last email that you make reference to, the one on 1367, you could see I had to get clarity from the HOD Agriculture. I also didn't understand all the complexities. To enable the state law advisors to say, as we start to try to figure out, can we redraft and advise Treasury? Are we able to get to some kind of clarity where we are? And in terms of urgency, let us try to finalize, enable us to say, yes, we can proceed. No, we are going to go back to EXCO to say we are not able to proceed. But in terms of the urgency of starting to implement, if it has agricultural dynamics, whether it was seasonal, whether it was agriculture, will be better placed to give that opinion.
Yes, because I think what's important as well about this email that you wrote is it's written on the 2nd of July, before the second agreement was signed. And after listening to your testimony yesterday, I really wondered why you simply, and when I say you as government, would not have said to the Department of Agriculture and Rural Development, scale back. It's one of the options you gave yesterday as you're describing what would happen. Or just postpone this and not sign the second agreement of the 5th and 7th of July. And hence my question relating to why you simply didn't say, as Moses had indicated in his email, you haven't provided. You can't do this. Stop it.
I think we were all functioning in the same environment at the time. Now, we've been through the budget process, we've been through Lagotlas, we know exactly what is in the budget. Now, days before, knowing what the budget is, there is a submission to EXCO to say, we want to upscale this project. EXCO pronounces itself. Now, would it be realistic then to expect we would go back to say, no, scale down this thing, you didn't make budget provision for it? Mr. Moses shared his concerns, but this does not rise to the level of issuing a written advice for a directive from executive authority having financial implications as provided for in the PFMA. His concerns, I think everyone was in agreement with him. Everyone had these concerns. That the affordability of this, we did not foresee at the time of compiling the budget for 2012-13, nor the financial implications going forward, given the broader fiscal framework within which we were operating.
No, thank you. Thanks for clarifying that. I'd like to move on. I'm trying to concertina matters this morning, to move on to the next aspect, and that really relates to the cancellation of the Estina contract. Did you verify the amount that was claimed by Estina on cancellation of that contract?
Provincial Treasury was not involved at all in the consultation process of reaching those funding, those provisions.
Again, you say it's not an area of oversight that you would have been expected to discharge.
No, we were just not involved. We were not consulted to say, this is where we are, this is going to be the financial implications arising from a cancellation. We subsequently asked the state law advisors, when you arrived at these conclusions on the amounts owed, what was the process? And they confirmed that agriculture confirmed to them that there were outstanding goods and services invoices and that they had verified it. So we were not involved in the process of quantifying or verifying. It was between agriculture and the state law advisors.
Okay, because from what we have seen of the evidence, and certainly what Mr. Jankelson said as well, this money was not due. This amount is not the amount that was due. But if you say you had no oversight role in relation to the 280 million that was paid to Estina, we'll deal with it with Mr. Tabata, because that's really where we are right now in the leading of his evidence. I now would like to move on to the FDC and the appointment of the FDC. The FDC being the Free State Development Corporation. I note that you state that just over 311 million rand was noted as possible irregular expenditure regarding Vrede Dairy in the financial year 2017-2018. In the same year, there was irregular expenditure regarding implementing agents that came to 815 million. So if you go to your supplementary bundle, page 4.1, That's where you set out a table showing this irregular expenditure. I give you these facts just for the sake of context. We'll come back to them. Because those...
What's the page on the
It's
supplementary?
page 41 in the supplementary
Thank you.
document, Chairman. Put that away, please. Can you find me my page 41? Now, first, the resolution of the 13th of June 2012 makes reference to the FDC.
That's correct.
And the FDC participating somehow in this Vrede Dairy Project. Then on cancellation, there is a specific resolution passed by EXCO. That's in 2014. That says the FDC should take over. You would have been part of the second decision, I take it.
That's correct, Chair.
Please explain why the FDC would have been required to assist, because as I understand matters, their core competency is not agriculture.
That's correct, Chair. That is how the memo came to EXCO with that recommendation. I have no information about what specific capacity FDC would have had at that time to be able to take over that project on behalf of the Department of Agriculture. But that is how the matter was concluded.
You know, I've actually looked at the Free State Development Corporation Act 6 of 1995, and I don't want to bother you about going to look at that. And I've looked at the powers of boards of directors. It is, Chairman, in the legislative bundle, but there's no particular reason to pull it out right now. And
I
I've
just
looked...
do remember that some of its sections are phrased very funnily.
Yes, Chairman, but at the end of the day, it says nothing about running an agricultural project.
Yeah,
It says a
okay.
lot about assisting projects source funding.
Yes.
That's, I
yes.
think, one of their core competencies.
Yeah.
There may just be, in the interpretation of these powers under Section 4, capital A, be powers to assist in managing a project. But I would have liked to think that that management must be tied up with the core skill of the FDC. But you say you can't assist us in explaining.
In broader background, many years before, I can't even, I would be guessing if I have to put a date to it. There used to be an entity called Agri-Eco in the Free State, and that was an agricultural development entity. It focused on specializing in agricultural projects. Through the years, I think it was disbanded, and broadly people were thinking one day it will evolve possibly from FDC as one of the streams of business units. But it was not, at the time FDC was appointed, I'm not aware that there was any specific agricultural expertise or development financing expertise in FDC that would make them suitable to take over this project.
This really is the conclusion I've come to, having looked at the documentation, both in your submissions and having looked at the Act. I'd like you to please just pick up ER 30, which is in volume A of what I've been calling your original submission. It's page 414.
Is it page?
414. Have you found it?
I'm at 414. I hope it's the same 414.
I'm sure it is. Now that, if you look down at probably the 5th or 6th paragraph, they speak here to the restructuring of the FDC.
Does your 414 start with the word merger projects?
That's the correct page, Chairman.
Okay.
So at paragraph, if I start with major and call that the first paragraph, it's 1, 2, 3, 4, 5, 6. And I really would like you to speak to, again, the reason that EXCO would have thought it prudent for the FDC, which obviously had had its own difficulties and quite recent difficulties, to become involved in the Vrede Dairy Project.
Thank you. Chair, as you indicated earlier, I'm not aware of the extent of consultations that there may have been between agriculture and FDC at the onset of the project. Mr. Ramehima at the time was the CEO of FDC. By then he had left as HOD Destia, he found himself in FDC. So I'm not sure what was the extent or the scope of discussions, whether there were any discussions around FDC's possible involvement, but also the conclusion of agriculture to make the recommendation that FDC would be appropriate now to take over the project. I don't know if there was specific consultations. I'm not really able to give you more details than that.
That's fine. What I thought I should also just, at least, even if it's just for purposes of putting it on the record, is point to your ER 107 at page 103, I beg your pardon, at page 1305 to 1306. So that would be volume C, at page 1305. To 1306.
Have you found mine? 1305.
Yes. The question is, I'm looking at the very last paragraph on page 1305. And I wonder if you have information on whether the FDC was appointed as an implementing agent or as a managing agent or as both. And I really would like you to have regard to the last paragraph of 1305 as you respond. Going across to 1306.
Chair, I am not able to assist you with clarity on that.
That's fine.
I just don't have enough information on how this arrangement was structured between
Yeah.
agriculture and FTC.
Okay.
Certainly, I know FTC then subsequently appointed an implementing or a project manager.
Yes.
Yeah, let me not confuse it. A project manager
Yeah.
to manage the dairy farm on its behalf. That is as far as I can
You
go.
can go. But can I ask you this generic question? Would the FTC be entitled to a management fee? You know, I'm always trying to trace the monies that have been paid to institutions. That's part of what we have to do as the Commission. And I want to find justification for the payment of monies to a particular institution.
I think if they do manage a project on behalf of any other department, obviously they would have operational expenditure, whether it's administration costs, etc., etc. So I would think that yes, they may be entitled to raise a management fee. If it is intergovernmental, like in this case, it should obviously be a convenient fee to at least cover expenses. They would not make money from it, but at least to cover whatever operational expenses they may incur.
So you're really suggesting that I should take this particular matter up with Mr. Tabete? He's the better
Yes.
person to answer
Yes, I
this
think
question.
the HOD and maybe the CEO of FDC will be able to
Respond.
respond in more detail on the arrangement between them.
That's fair enough. But can I then take you back to that very first proposition I put to you about the irregular expenditure of 311 million, which you mention in your paragraph?
Can you just repeat the reference to that paragraph?
It was your supplementary affidavit
Oh, yes.
on page 41. You have a table. And I thought that was rather concerning looking at those amounts because it essentially reflects for the financial year 2017-18 irregular expenditure of over R1 billion.
Yes, Chairperson, this extract comes from the annual financial statements for that particular financial year. Now, the possible irregular expenditure regarding implementing agents, the 815.966 million, this has nothing to do with either Vrede Dairy or with FTC. These are implementing agents used by the Department of Agriculture to implement agricultural projects on behalf of beneficiaries, mostly utilizing the conditional grant funding of CASP and Ilima Letsema. So there's no direct link there. These implementing agents, they were introduced in the 11-12 financial year after the department had realized, and it was in the audit reports of the prior financial years, that there were problems as the department were procuring on behalf of beneficiaries. There were 3 financial years that the Auditor-General mentions that was under investigation. The actual services or goods rendered, the beneficiaries, that they exist, that they not exist. So the department brought in implementing agents as a mechanism to improve efficiency. They were appointed through a tender process. I know of 3 that was appointed for, there were 3 main implementing agents. There seem to also have been then 1 or 2 other implementing agents in the years between 2011-12 to 2017-18, 2018-19. And after the first tender period, the contract period, a second tender was advertised and awarded. But they have nothing, they deal with all other agricultural projects. Now, these implementing agents, the funding allocated for CASP and Ilima Letsema projects were already 11-12, they were budgeted as transfer payments. So when it came to Istina, it was exactly the same arrangement. That precedent had already been created, that, say, implementing agent A is responsible for this 10 projects. If it's 10 million, we transfer the 10 million to them. The agreements were structured in a way that the implementing agent was acting on behalf of the beneficiary. So equally, the moment the funds were transferred, it became unrequited funds, ceased to be public money. So no one followed in audit also that audit trail.
Can I ask you to pause there, because that's precisely where the problem sits for us as a commission, because Provincial Treasury has an oversight role. Provincial Treasury is responsible for ensuring that funds that have been allocated are used in a particular manner. I'm really just putting it as a general statement. You then come to a project such as the Vrede Dairy Project, which is not on the same level. You can't draw parallels between that project and other projects where implementing agents were appointed. Your general statement on implementing agents, I really have no difficulty with, because there the beneficiary does play a part in appointing the implementing agent. This is really your evidence. Am I correct? The beneficiary, or the farmer, as Mr. Tabata calls them, would be assisting in appointing the implementing agent.
To my knowledge, they had no role in the appointment of the implementing agent.
Well, I know that Mr. Tabata's view was certainly that the farmer or the beneficiary assists in the appointment, but it was different with Estina. With Estina, there was no beneficiary. So the implementing agent was appointed by the department. So if the department has some supervisory role in making sure that monies transferred to the implementing agent are used for the purposes that those monies were transferred for, I would have thought that the watchdog, Provincial Treasury, would be checking to make sure that indeed this is what has happened. That's where you fit in, for my purposes, into this equation.
Yes, in the sense, did the department make provision for the budget? Is the transfers that they have made within the projected schedules that they would have provided to us? And was the money transferred to the entity appointed? But further than that, what the implementing agent did with the money, how they handled the money, how they procured and so forth, that is not Treasury's role.
But do you not interrogate the annual financial plans, the annual performance plans, the annual financial statements that a particular department prepares?
No. Annual performance plans are drafted by the department.
Yes.
You go through normally a strategic planning session or some kind of strategy session. You have your quarterly reviews. It builds up. Then you formulate your annual performance plan. It gets tabled in the legislature. It never gets tabled in the Executive Council, for example. It gets tabled in the legislature before the budget vote speech of a department. From there, it gets referred to the relevant portfolio committee of the legislature that considers it. It reports and makes recommendations back to the legislature. Treasury does not play a role in that process. The role we will play is to ensure that what is taken up in the annexures to the APP, where you bring in and set out the details of your infrastructure projects, that those projects then talk to your table B5 projects that's in the Appropriation Act or the Adjustment Appropriation Act.
You see, the difficulty I have with your explanation is you also wear the hat of being a member of the legislature. So not only are you head of Treasury, Provincial Treasury, you're also a member of the legislature. And when people come and place their budgets, I'll call them that just in a general term, asking for monies for particular items that they've set out, you are a member of the legislature. The impression I am left with, which you must please correct if it's wrong, is that the legislature simply rubber stamps, doesn't make inquiry as to why monies that were set out in the previous year have got, how those were used and why people are coming back to ask for certain amounts, why it is that implementing agents are performing the way they're performing, why it is that the Auditor-General is forever complaining about the manner in which monies are accounted for. What is the role of the legislature in those circumstances?
Members of the Executive Council don't participate in portfolio committees. They can attend, and when they are invited to come and report, for example, Treasury would go and report to the Finance Committee or to Public Accounts Committee on expenditure trends, revenue, audit outcomes, and so forth. But in terms of separation of powers, the members of the legislature serving in a specific portfolio committees from all parties, obviously, they do that detailed interrogation of the annual performance plan. There would be reports that went back to the legislature in a sitting of the legislature that would have gotten adopted. Those recommendations would have been communicated to the Premier. Then it gets disbursed to relevant departments. Each one deals with his or her own section. We must again respond. When it comes to the audit reports, that belongs to the Public Accounts Committee. So as you table your annual report with the audited financial statements, it gets referred for consideration to the Public Accounts Committee. All departments every year gets called in. Auditor-General are part of those sessions, Treasury is part of those sessions. And they interrogate those reports. Equally, they formulate the responses or the recommendations to the legislature. If the legislature approves, for example, unauthorized expenditure, they may recommend it with funding or without funding. If unauthorized expenditure is recommended with funding, it means we have to find the money in the budget to fund. If it's authorized without funding, the department must accommodate that funding from within its own budget. We then formalize that into a finance bill in any particular financial year. But as we sit here, I am not able to say the portfolio committee responsible for agriculture said X, Y, Z about these APPs, about the execution of the project, about whether they conducted site visits and so forth. There are people relevant in the legislature, the chairperson of the portfolio committee and the chairperson of the Public Accounts Committee. They may be able to shed light on the legislature's handling or processing of matters related to agriculture, including Vrede Dairy and implementing agents during the period.
So you are saying in your term as MEC, at no stage did any of the relevant portfolio committees ask you to come in and address them on the issues they were picking up?
No, I think I highlight in, it's either the main affidavit or the supplementary affidavit that, I think is it towards 2018, that it was the first time we were invited to a committee meeting to come and explain. And the date of that meeting coincided with a by-election in my constituency. And we sent a report and we said officials will be able, if they continue to go and present, but I had responsibilities in the constituency for the by-election. I was later informed that that meeting was postponed. So that was the only meeting. I'm not talking about the normal Public Accounts Committee meetings and Finance Committee meetings where we would be reporting on provincial income and expenditure, those things. We would have been reported, but on Vrede Dairy specifically, that is the only portfolio committee specifically that I was invited to.
And on that occasion, you couldn't attend?
Yes. And it was towards, I think, somewhere in 2018.
Maybe this is a good time, because we're talking about the Auditor-General and the Public Accounts Committee. Maybe this is a good time just to help the Commission and the Chairman understand how transfer funds were intended to be reported. And in particular in relation to implementing agents, which is why I'm just putting the two issues together. We have implementing agents who are given a lump sum. How do they account for that? I know there's been a long debate. Just take us through that debate.
Thanks, Chair. That's the 2-year debate that we had on the accounting treatment of transfer payments. As it appears now in all the annual reports, it is in the report of the accounting officer. It gets disclosed as transfer payment to entities other than public entities. So anyone else that you transferred money to, whether it's universities, private business, sports clubs, anyone else, you declare it as such. So in this case, I've extracted the relevant sections from all those annual reports to say it was disclosed, it's a transfer to Vrede Dairy. I think the first year it was to Easton and subsequently it was Vrede Dairy. And the amount that was disclosed and the purpose the purpose would be project implementation and the amount would be reflected. And it ends there. There were no further details than that. And that was what the AG was raising to say, it's fine, you tell us, say for example, you've transferred 10 million. He wanted to know what happened to the 10 million. And because it was classified as a transfer payment, there was no requirement to further set out the details of the 10 million. It wasn't broken down further into goods and services or any other category of your standard chart of accounts.
Please just refresh my memory on how a transfer payment comes about. Now let's go back to the basics. What's a transfer payment? How does it come about?
Essentially it is when you do not intend to procure goods and services yourself by yourself as a department. You don't go through your own tender process or process of quotations. You take the 10 million, you have an agreement, you transfer the money as is there.
So, you have an agreement with whom? With the person to whom you want to transfer
yes,
the money?
Yes. Whether it is a private business, you will say, I'm giving you 10 million. There should be a SLA or some kind of contractual arrangement.
Yes.
But the transfer payments usually gets reflected as, if it relates to infrastructure, for example, it would be infrastructure, capital expenditure would be new infrastructure, capital expenditure current would be maintenance. So there is I've set out in details.
Yeah, I know you
yes.
dealt with the issue quite at length, yes. And I did read that, but that was about 2 days ago, if not 3. But what instrument makes provision for transfer payments in government departments or in Treasury?
I think broadly, provision is made in the PFMA, the Treasury regulations, your standard chart of accounts. It is provided for, but obviously with certain conditions that has to be met when you make such transfer payments. It's, for example, yesterday I made reference to the transfer payments we make to non-profit organizations through social development.
That would be, say, for example, you are Department of Social Development.
Yes.
You need the post office, or you need cash pay master services, or you need some entity to play a role that will facilitate the execution of functions that you have to do as a department. Is that a good example?
Yes, Chair, I'll rather use an example in our provincial context.
Yes.
We have early childhood development centers that renders services basically on behalf of government.
Yes, what did you say, what center? Or
Early childhood development centers,
yes,
ECDs,
yes,
for
yes,
example.
yeah.
Or orphanages.
Yes.
Or children in distress. So those are all transfer payments. There's a formula that's set out in whatever relevant act to say X amount per day per child, you get to an amount. So that amount gets simply transferred to that non-profit organization. Obviously, they must be registered.
Yeah.
They must comply with
Yeah.
certain regulations and conditions.
Yeah.
But no one follows that money.
But don't they have to account to you annually as to how they used the money that you gave them? before you can give them another amount next year.
There would be a reporting mechanism to say they must submit reports to social development, not to Treasury.
Yes.
And in terms of NPO Act, they would probably submit financial statements to the National Department of Social Development. So it's regulated. But it becomes impossible for us or the Auditor-General to go. Imagine how many of these small entities that you would have to audit, because now we're talking hundreds of millions of rands. So transfer payments as such is not a problem. It's the utilization thereof. It became a problem that I don't think anyone foresaw, that it's going to reach the stage where questions would be asked on the utilization and the procurement of implementing agents on behalf of beneficiaries. And I think Advocate mentioned yesterday, it took us a significant period of time, 2 years basically, to get to finality around classification. And ultimately, it affected the whole country. It was not a Free State issue. It affected everyone equally on how we've been dealing with classification of transfer payments.
Well, the example you make of early childhood centers, would those entities be regarded as implementing agents or not? In other words, do you associate transfer payments necessarily with implementing agents or not necessarily?
Not necessarily only an implementing agent in the sense that we are dealing with it in agriculture, but when they render a service on behalf of government.
That is an implementing agent. It's acting on behalf of government.
Yes.
Yes.
I think that would be broadly my understanding, Chair.
Yes, but in the example that you have given of early childhood center, you would not view the center in that way, would you?
They essentially render a service on behalf of government. They are not necessarily implementing something on behalf of government.
Yes, yes. So because I'm trying to see whether when you make that transfer to an entity such as an early childhood center, whether you are making a donation because they perform the kind of functions that you recognize are important in society, and therefore, because you have made a donation, maybe there might not be a need for certain things, or are they an implementing agents, or is it none of the above?
The accounting treatment, Chair, of donations and gifts is separate again.
Yes.
Any donation gift above 100,000, you need authorization of the legislature. It's disclosed separately. So it's not, we're not giving them.
It's not a donation.
It's not a donation, no.
So.
But ultimately, at the conclusion of this process, the transfer payments to NPO, do we call them NPOs, or in that sector, was exempted from the classification. Yeah. Yes.
Just repeat what you have just said.
At the end of that process of this classification issue between transfer payments and goods and services for implementing agents, although we said we were of the opinion that the principle applied, they were exempted from the classification. That meant that they had to, all the departments had to reclassify from transfer payments to goods and services. The social development sector was exempted from that. So there was a recognition. It's not exactly the same as an implementing agent.
The early childhood centers, yes. So they were exempted from that.
Yes, they were at the end of the process exempted.
Or did that need a particular instrument to be?
I think that was in the final guidance issued by National Treasury.
Yes.
It would have been included that the exemption applies to this and this categories.
Yes. So the concept of transfer payments, you say, is provided for in the PFMA and other instruments.
Treasury regulations and so forth, yes, Chair.
As such, within government, it's accepted. What did cause some problem or debates was how it was utilized in certain circumstances which then gave rise to the 2-year debate or discussion that you talked about. Is that right?
That's correct, Chair.
Yes. Now, with regard to implementing agents, in where you are dealing with an implementing agent, you have to use transfer payments, or is there another way of transferring money to them other than through the transfer payment mechanism?
In this context that we are dealing with of agriculture, that is how it was structured. That the
Yes.
funding was transferred to them, they procured on behalf of beneficiaries. And the argument was then that they did not need to follow SEM
Procurement
procedures or
procedures.
procurement policies.
Yes, yes. But that was wrong, was it not?
I think the Auditor-General consistently raised the issue for a number of years until the clarification was finalized to say no, they should use procurement processes.
You must tell me what your own observations of views are. You were the MEC for Finance, or I'm not keeping up with when you were DG, when you were MEC for Finance. But the impression I get from what I have been told about the implementing agents in the Vrede Dairy context gives me the impression that this was just a way of circumventing procurement procedures. That's the impression I have. It's not the final impression. I'll hear more evidence. Maybe I'll change the way I'm thinking about it now. But what can you say to me about that? If you are able to say anything.
I think because we have known this arrangement of implementing agents from before Istina, at the time it was introduced, it wasn't new. But we were very aware of the concerns raised by the Auditor-General in terms of follow the money, that you could not follow the money. When the transfer was made, it was made. There was no further trace. And I think we did share his concerns about value for money with all implementing agents, not only the CASP conditional grants, Ilima Letsema, but also Istina. It is a consistent pattern that we should be ensuring that there's value for money that gets transferred.
Because somehow, apart from the question of whether a department like Department of Agriculture doesn't have or didn't have people with the relevant skills and qualifications to do what was necessary, leaving that aside and assuming that they didn't have, if there's an obligation on the Department of Agriculture to ensure that, taxpayers' money allocated to it is used properly, and that and they just appoint an implementing agent in the manner in which it seems to have been done here. It seems that in effect you are taking taxpayers' money and just giving it to somebody without being able to ensure that that somebody will use that money properly and for what it is supposed to be used for. That's the impression I have. I don't know if you are able to comment on that.
Yes, Chair, I think we had no other insight on how Istina specifically was identified as an implementing agent because there wasn't a public process. What was illustrated or provided to us to say it is a similar type of arrangement, though on a much bigger scale. Agriculture said to us, we have partnership agreements, for example, with VKB, whatever it is that VKB does. But that was how it was contextualized to say it is no different from other existing partnership agreements, though it might be at a bigger level. But the concern was consistent, that the way in which we deal with value for money issues relating to transfer payments has been a concern for the better part of at least 7-8 financial years.
Did you get to know either at some stage during those years or after the Commission had started hearing evidence relating to Estina that Estina actually, as a company, had nothing to do with farming and agriculture at the time it was appointed, and that actually at the time it was appointed, its finances, on what we have been told, I think it had 16 comma something rand in its account, in circumstances where the agreement that was concluded with the Department of Agriculture required it to contribute millions into the project. Did you get to know about that at some stage during those years, or only when the Commission was hearing evidence?
No. No such information was made available to either myself as DG at the time this project started, or to Treasury in that Treasury Committee meeting and the exchange of documents. There was nothing that suggested that a due diligence exercise would have provided us with this information. I think that was relatively new to us when such information was provided to the Commission. That was not known to us at the time.
Of course, what it does raise is the issue of oversight on the part of the Provincial Treasury. We talked about that yesterday. We talked about the limitations and so on. But it must be concerning, or it must have concerned you quite a lot when you did hear that, because you must have thought, well, whatever limitations we must have, we may have had, there must be a way of picking up something like that in one way or another. That's my thinking now. What do you say to that?
Yes, Chairperson, I would agree that it raises concerns, but at that time, this was before the introduction of the Central Supply Database System of National Treasury. So I think registering an entity on the database was almost much easier than it is to register on CSD in terms of what was required. So I think the introduction of CSD by National Treasury has brought in a lot of additional internal controls. It would have probably been wise to say, if we undertake this kind of project, like in many other type of projects, a tender would be advertised to say a service provider or a bidder must illustrate financial capacity with a bank account statement. He must have 10 rand in the bank. So I think the mechanisms existed. It is in how we utilize them that exposed us to an unnecessary risk, probably, in this case. I think there were various other things that the department could have done to mitigate against possible risks to embark on this project. But as the Audit Committee itself of Agriculture reflects in a number of audit reports, the risk component of the department was very new and very undercapacitated. I think both in terms of numbers and in terms of ability to execute. There are obvious challenges with the public-private partnership arrangements in government, purely because it's a general perception that they take forever to get off the ground and to get projects moving. So there's almost always a reluctance against the triple P format when you want to start implementing a project. But I would agree that there should probably have been other ways to mitigate against the financial risks that the project brought with it.
Would it be correct to say, had this been put to tender, this would have, Estina, if its financial situation was the way it has been described in this commission, and if it had nothing to do with farming or agriculture, it's unlikely that it would have been appointed.
On its own, without having the background, track record or financial capacity, it would have been challenging to be appointed on its own, though it could have gone into a special purpose kind of vehicle through a joint venture or something like that.
But do you say the tender, if this had been subjected to a tender process, these issues would have come out in terms of in what sector does it operate, what experience does it have, what is its financial muscle, particularly if the agreement was going to require that whichever service provider is appointed would have to make a contribution of millions into the project.
Yes, your bid specifications would have gone into far more details to say the type of bidder that we are looking for or the type of partner that we are looking for must have this certain level of expertise, they must have proven financial muscle to a certain quantum. Your bid specification process would have narrowed down and mitigated in itself against the risk that you would expose the department to.
But you would agree, would you not, that even if we were dealing with circumstances which justified not putting this through a tender process, any head of department ought to have done the necessary homework to make sure that they didn't appoint a company that had 16 rand in its bank account and required to pay millions of rands into the project.
Chairperson, I would say that is reasonable.
Yes, okay, thank you.
Chairperson, just to add one little piece to what you've been dealing with now.
Yes.
The relevant section in the PFMA, section 38(1)J,
Yes.
that speaks to the things that you're raising.
Yes.
Before funds can be transferred, certain things must be in place
Yes.
in the entity that the transfer is being made
to which transfer is made.
Yes.
Yes.
And the other provision would be Treasury Regulation 8.4.1. So it's section 38(1)J read with Treasury Regulation 8.4.1, which speaks to the checks and balances that you have been summarizing.
Thank you.
And the question then still remains is what is the Provincial Treasury's role in ensuring that these particular provisions are complied with?
Yes. Yeah.
Chairman, I see that we have gone beyond 15:15. I don't know if you want to push until 12, because if we do, we will be done, or if you would rather take a short break now.
Okay, I think let's take the short break. So we might end up going to 15:15 or thereabouts.
I've
12.
taken note of your request yesterday, Chairman, and
Yeah.
edited.
As long as you don't feel that there are issues that you are not able to do justice to, so important issues.
Not at all, Chairman.
Yeah. Okay. All right. We will take the tea adjournment now. It's 24 minutes past. We will come back at 22:12. We adjourn.
All rise.
2010, it was a copy of the New Age was R3.50, which means, of course, I don't know whether anybody has established exactly how many copies where the provincial government agreed to buy per day, but if it was 4,000, that would be 4,000 times 350, and leaving out 50 cents, that means per day it would be 3 times 4,000, that's I think 120,000 rand a day. Am I right? I think Junior Council is much more clued up on these things. 120,000 rand a day in 5 days, that would be 600,000 a day.
I'm advised it would be 12,000, Chairman. Like you, I did not do the maths on this one. The brains had it.
Okay, I'm not going to continue. It just shows it was a good decision to take law, not anything else. So about 12,000 rand. So in 5 days, that would be, what, about 60 or thereabout. And so over a month, you could be looking at about just under 200,000 or 180 or thereabout. That's what you could be looking at.
Per month.
A month. Okay. You might be much better off with figures, I'm not sure. But
The latter part, Chairperson, sounded more accurate, but I think we did indicate yesterday we will extract that information and provide to the Commission.
Yes. And it may be that it does already exist within the records of the Commission because of the evidence about GCIS and Mr. Mani, and it may be that it exists, but it would be convenient if it could be extracted again. But it's not as much as the first figure that I mentioned. Yes, thank you.
Thank you, Chairman. Ms. Rockman, just one or two questions still related to transfer payments that I just want to either clarify or confirm with you. One, not all transfer payments contain conditions. Is that correct? Some do, others don't.
Chair, I think in general there would be conditions, whether it is a national conditional grant or whether it is like infrastructure enhancement, allocation, that would also still come with conditions.
Okay, so you say that the general rule is that there would be conditions.
Yes, whether it's a
attached to it.
national or a provincial type of grant, and then between the relevant department and the service provider, the conditions around a particular transfer payment for particular purposes would be set out in a service level agreement at the very least.
Okay.
1 second. Please send an SMS to the referendum and say he must tell Karen Moore, the journalist, that I might only be able to so she must wait for me. I didn't realize this was on.
Yes, I was wondering if I should say so or not. I've learned at my peril that.
But it's nothing concerning security. Yes, thank you.
Thank you, Chairman.
I just have an appointment to keep, which I see I won't be able to keep until, I thought we would finish by 12, but let's continue.
Then the next issue really is just to point out more for record purposes that the Free State Province Appropriation Act of 2012-2013, that financial year, defines transfers and subsidies as, and I quote, any payments made by a provincial department to another organ of state or any other person in respect of which the relevant department does not receive anything of similar value directly in return, and includes the payment of conditional grants, close quotes. I just thought it's apposite to put that in for purposes of the record, Chairman. You're happy enough with
Yes. Thanks, Chair.
that? The question really would then be, I know this was the Appropriation Act of 2012, 2013, but the definition would not change over the years.
That's correct, Chair. There might be minor amendments, but the essence of it would remain.
Thank you. Next question, is it correct that where transfer funds are not used for the intended purpose, or where there is a failure to account for their use, they can be reclaimed?
I think that would be the general rule.
It
and
is the
general
general
understanding, yeah.
But reclaimed by whom?
By the transferring department.
Again, Provincial Treasury in this instance would not have a role, a direct role
No.
in that reclaiming process. Then the last question really is really more of an observation. And that is that the 2018 decision or guidelines from National Treasury have resolved how transfer payments should be classified. Where goods and services are being procured, that would generally fall within the supply chain management processes. And if not, there is still a category for straightforward transfer payments.
That would be correct, Chair. And by implication, it now means that with the reclassification exercise, all departments affected have to go back in time and start reclassifying and start clearing out whatever the issues were. So if you had classified a transfer payment of 10 million, you'll have to reclassify now that 10 million and break it up into goods and services, and you must provide your relevant supporting documentation to justify the allocation of that 10 million accordingly.
Yes, but the guide or the instruction was backdated to 2016, if I'm not wrong. So it's as of 2016, they would
Yes.
have to go through that exercise.
Yes.
Okay. Can I then just bring you back to what started this discussion, which was the schedule put on your supplementary affidavit, page 41. We were talking about irregular expenditure, and the first one you then dealt with was possible irregular expenditure regarding implementing agents. That was the 815 million, or almost 816 million. And you explained that it didn't necessarily mean it's only in relation to Vrede, but it could be from anywhere else.
Chair, yes, this was excluding Vrede.
It excluded
Yes.
Vrede. Good. The one I'm now interested in is the possible irregular expenditure regarding Vrede Dairy of 311 million. Now that 311 million represents just that one financial year, 2017 to 2018, or does it go beyond that?
That is a level of detail I don't have access to at this stage. This is a calculation done by the department. It's audited by the AG, so I would not here be able to say how that 311 million is broken down. Whether it is only Estina, whether it includes even the transfer payments to FTC as well. So there is a different level of details that I did not have at my disposal here.
I understand that, and I would have assumed that it includes monies that were paid to FTC because they were appointed as of 2014.
That's correct.
But my question was that represents possible irregular expenditure regarding Vrede Dairy in the financial year 2017-2018.
That is all irregular expenditure under investigation. It might not be only for that financial year.
So are you sure about that? Because, I mean, when you look at this schedule, top right, it clearly says 2017-2018. Why would it include other years? The note here says 2017-2018. And if you look at your affidavit, in fact, you find that there are other irregularities that you have noted in the same affidavit. I just did not want to go into all that detail. So this is page 41.
I'm just trying to find the supporting document itself. It is disclosed, 1718 in this instance means it's disclosed at the financial year ending 31st March 2018.
Yes. But it covers, all I want to establish is that it covers that preceding 12-month period, or does it go beyond that? Is it a cumulative amount
It might
over
be a
the
cumulative
years?
amount.
It
yeah.
might be, you
Yeah.
say. Are you able to establish that for us and send us the relevant documentation that supports? Because I'll tell you why this is of interest, certainly to us as evidence leaders, is because if in one financial year there was irregular expenditure regarding Vrede Dairy only of 311 million rand, that's a large sum of money.
That is why I'm saying, Chair, it's a cumulative. I know the irregular expenditure regarding implementing agents, the disclosure of 815 is a cumulative from the 2011-12 financial year.
I think that the Commission would really appreciate literally a one-pager, if you would, with supporting documentation, so that we are left with the correct impression as to whether all this was spent in 1 year paying for services rendered at Vrede Dairy, or if it was a cumulative amount going back to, say, 2011, 2012.
We will certainly be able to extract that, Chair.
That the second item on that incident list, the 2017-2018 one, second item reads, deviations approved by the accounting officer not accepted. The impression I was left with, and it probably is my fault, not Mr. Tabete's, is that once an accounting officer has decided to deviate, nobody can question it. But it's obvious that when one reads this line item, 2 million rands worth of money spent on a deviation that was approved by the accounting officer but not accepted, is something that would be noted.
Yes, that's correct, Chair. The decision is ultimately not absolute. It is still subject to review. It must be reasonable. The nature of the decision must be reasonable, justifiable. We had a very long part of the engagements with the AG over probably 2-year period was the implications of auditing the discretion of an accounting officer. But
Yes.
that discretion is not absolute. I think we reached common ground on that. And I was informed by the state law advisors that the judgment of the Constitutional Court in Tasima also brought final clarity around what is an administrative act and how it remains in effect until it is set aside. So I think all provincial national government departments or the broader public sector has to internalize the implications of that act and how it gets permeated through standard operating procedures, that if something is found irregular, how do we deal with it? It can't be found irregular and it's just left that way.
Well, I must confess that when I read your affidavit on, on this issue, I was surprised that you and whoever from the National Treasury and Provincial Treasury, the National Treasury, and I think the Accountant General, I don't know whether the Auditor General as well, were all concerned about whether this was administrative action or not. And I didn't understand that, because you people are not a court. You know, it's a court that has to decide whether an administrative action is reasonable or justifiable or not. You people are not courts. So your own role, as I understand it, would be different. And I gained the impression, and you must just feel free to make your observations. It seemed to me, I gained the impression that somebody was just trying to unjustifiably prevent people from scrutinizing action that they are entitled to scrutinize.
I think, Chairperson, it was the basis for disclosing the expenditure as possible, irregular or not. I think that was where the matter started from.
Yes, but
and
the
certainly,
question,
if the expenditure was declared irregular, you would expect that
something must be done.
Someone would have to go to court to set aside the agreement.
Well, I don't know why you would necessarily think about going to court, because, I mean, you agreed yesterday that the Provincial Treasury plays an oversight role, performs an oversight role. There might be limitations, but that's part of its function. Now, monitoring must mean you are checking whether things have been done properly or are being done properly. And obviously, there must be something you are able to do if you pick up that something is not being done properly. And I would just be surprised if what it meant is that you must now go to court each time you pick up something in the exercise of your monitoring exercise. Each time you must go to court instead of sitting down with the head of department or whoever and say, but this is not right, and getting it sorted out. I mean, how much money will end up being used for going to court if each time you pick up something that's not being done properly, you must go to court? I think lawyers will be very rich.
Yes, I think, Chairperson, if you read through the audit and accounting treatment section, I think we detailed the response of the HOD to the Auditor-General that sets out that basis. And if you remember where this started, June 2012, when the matter first was brought to the Provincial Accountant General, she had already advised at that point that this may be irregular. So it's not like it was not known. But the responsibility in this case was with the accounting officer, notwithstanding many years of advisors to say, both Auditor General saying, these are our audit findings, but he very firmly set out the grounds on which he disagrees with the Auditor General's findings. Now, there's no basis for Treasury to then say, we are instructing you to declare this as irregular. Ultimately, it is his action, but in the broader context, it should be the accounting officer then that reverses his own decision. That would be the reasonable expectation. I agree with you. It shouldn't be necessary for Treasury or anyone else to have to approach court. It should be the accounting officer taking the corrective action. But in this case, there was no agreement that he did not follow the correct procedure.
But also, I would have imagined that there would be mechanisms that could be invoked if the right authority, whether you say the right authority is the Auditor-General or Provincial Treasury, says, but this is not right. We are given the obligation to monitor. You are not given the obligation to monitor yourself. We are the ones who are given the obligation to monitor you. We look at this, we say this is irregular. If it's quite clear what should be done as far as Provincial Treasury is concerned and it disagrees, there must be a mechanism. I don't know whether it would include approaching the MEC, approaching the Premier or whatever, but there should be a way in which somebody's authority is accepted by that functionary to say, well, once this authority has said this should be changed, then I must decide. If I don't want to change it, maybe I should go, if I feel so strongly about it. But once the right authority says it's not right and they've had my side, they are not persuaded, there should be finality. So I'm just sharing with you the impression I had when I read that part of your affidavit. And Mr. Tabata is still coming back here, and I will give him a chance to tell me what he thinks. But that's the impression I got, that somebody was just trying unjustifiably to protect his decision from scrutiny by authorities that are allowed to scrutinize that decision.
The way practically we also deal with the chairperson is, if these type of matters emerge, whether it's during a financial year or during audit period, we share with the Auditor-General, the advices issued, whether it was in a CFO forum, whether it was on an individual basis. Often most of the time we are in agreement with the Auditor-General. There's very seldom huge discrepancies in interpretation.
Yes.
I think one of the positive developments is the Public Audit Amendment Act that will enforce consequence management.
Yes.
Because it doesn't help. We have reached that stage where year after year the same or similar findings are made, and we go through the same processes, we issue the same advice, and nothing changes. I think the Public Audit Amendment Act and the consequence management that will come through as the ultimate last resort almost, if all other mechanisms internally in government has failed. I think that is going to make a substantial difference to the environment in which we work. I mean, there are basic other requirements. If you sign off a deviation, you are supposed to register it, send it to Treasury, send it to AG, send it here, send it there. That does not necessarily mean anything happens to it. We can say, yes, we've noted and we advise you that we are not in agreement with you. And then what? So I think in recent times, there have been substantial developments, like with the Public Audit Amendment Act, that will significantly bring these things under control than just leaving it. And
well, I hope they will, but one continues to be concerned about the fact that public service government has got lots of laws, lots of policies, lots of mechanisms for dealing with situations, but they don't get used. I mean, I often say, the way public service doesn't deal with issues of poor performance by staff and so on, it's like people who work for government know that there will be no consequences unless I'm guilty of fraud, but even then, in case they catch me, which is unlikely. Many people just don't do their job. That's why there are such problems about service delivery. People are supposed to supervise other people who are supposed to do their job, they don't supervise them. And if they don't do their job, there are no consequences. That's why a lot of people complain about service delivery. It's not like the mechanisms are not there. They are there, but they don't get implemented. And those who are supposed to implement them and fail to implement them don't suffer any consequences, year in, year out. I know I'm just, you might not be able to say anything. I'm just, yes, Mr. Rasha.
Thank you, Chairman. Chairman, just for the record, it might be useful when we get to reading our transcripts, just to make a note of that particular judgment that did, I think, change the attitude of the Free State government. And that is the Department of Transport and Others versus Tasmina, spelled TASMINA, Pty Limited, 2017, Volume 2, SA 622, CC, Constitutional Court Decision.
Yes, thank you.
Chairman, I will very quickly just run through some of the other irregularities that are actually noted in the supplementary affidavit of
Yes.
Ms. Rockman. And if you don't mind me going from back to front.
Yeah, that's fine.
At page 37, for the 2014-2015 year, you have non-compliance with SCM policies, the very issue you're dealing with now, at 17,708,000 rand. At page 36, for the 2013-2014 financial year, again, non-compliance with supply chain management procedures. There, the amount was 21,386,000. You'll find that on page 36 of the supplementary affidavit, Chairman. And then for the 2013-2014, I think that's Ms. Rockman, I think that should be 2012-2013. I think that because the last one we did just now was 2013-14. So I think this should actually be 2012-2013, Chairman. Non-compliance with SCM procedures was in the amount of 23,309,000. So these are significant amounts, especially if you look at them over the years, and the comments you make about consequence management and people taking responsibility for decisions that they take really feeds into these figures. And how to implement what people in authority tell us to do certainly fits again into this paradigm. Chairman, I would like to just finish off with just a comment. I just want to briefly go back to the FDC and three issues there, again arising from your affidavit, and this time I looked at ER 99.4 at page 1141, that would be bundle C. But really and also ER 98, page 1110, again volume C, and those are really just comments, one from the Auditor-General, the other from the department relating to monies that were paid to the FDC, Ms. Rockman. And it would appear that in 2017-2018, 20 million was paid to the FDC, and in prior years, 51.2 million cumulatively would have been paid to the FDC. These are significant amounts, and the question really is, which we'll discuss with Mr. Tabata, is the extent to which these types of sums were accommodated in his provisioning system for the Vrede Dairy Project. But the other comment I would like to make is I looked at your supplementary bundle and at tag 23A, so it's annexure 23 capital A, 23A in the supplementary, capital A in the supplementary bundle. There is actually an interesting letter from the service provider appointed by the FDC to render services at the Vrede Dairy Farm project. And it's a letter from their attorneys. Where they lament the fact that at paragraph 3 of that letter, that they were not properly paid. So they say, although there's no obligation to provide reasons for the cancellation, they were cancelling their contract with FDC. Our instructions are to record that the main reasons for terminating the agreement is due to your lack of cooperation, semicolon, failure to provide our client with instructions, and in brackets, including but not limited to your failure to provide instruction with respect to the turnaround strategy submitted to yourselves, and despite several reminders over the past year, close brackets, and above all, failure to make payment of amounts due to our clients. As a result, our client has been unable to make payment to employees and other creditors. The agreement will therefore come to an end on the 13th day following the date of delivery of this letter. So this is ECHU, a service provider appointed by FDC, writing to FDC. And the reason I bring this to your attention and the chairman's attention is, again, it speaks to the competencies of the FDC. Were they really the best entity to take over the running of the Vrede Dairy Farm? When one, we have already laid evidence that they themselves were in trouble and were being restructured. We've dealt with that. And at the tail end in 2018, there are real difficulties that they seem not to be able to resolve. I don't know if you want to comment on this.
Thank you, Chair. Just to say, after the action taken to place the farm under a preservation order. Yeah.
When the curator was appointed.
Yes. The continuation of ETSU was with the approval of the curator. But we were consistently asked to intervene in the delay of payments between FDC and agriculture. So agriculture would delay payments to FDC saying they require information. FDC would say, we have given you the information, we want payment. In the process, no one paid ETSU. So ETSU ended up almost carrying the costs of the Vrede Dairy Farm on its own, in the hope that government will now one day sort out whatever bureaucracy problems stood in the way of processing payments. And I think at this stage they reached that point to say, we will rather walk away and leave you to deal with the farm on your own, whether it's FDC on its own or FDC handing it back then to agriculture.
I think it's actually convenient just to, again, just solicit your view on even ECHU itself, its competency to operate and run a dairy farm. Because as I understand their competencies, it's in the construction project management area. Again, there's no particular dairy or agricultural competence that sits in ECHU. I don't know if you have a response to that.
I know ETSU as a project management in other industries, not related to agriculture, but I can't comment on what capacity they had at that point in time to take up the appointment.
Yeah.
Then
Are we almost there?
Yes, Chairman. The last one really is Mr. Damini's comment. He suggested to the Chair that Vrede, the dairy project, should be shut down because it's brought nothing but angst and pain and discord to their community. I don't know if you want to give the chairman a view on that.
I have a lot of appreciation and empathy for the feelings and the sentiments of the intended beneficiaries who have gained nothing from this project. I don't think it's too late. I think the project, to some extent, is viable with the correct skills and knowledgeable people, maybe not at the level that it was envisaged. But certainly there is benefit, there is inherent benefit to involve beneficiaries in a project of this nature. I don't think it should simply be closed down completely. I think there is still something that can be salvaged from the project and slowly built and to be expanded into a better income opportunities for knowledgeable people who have interest in agriculture, not random people that does not have agriculture, a love for agriculture at heart.
Thank you. The last area I want us to touch on is evidence given to this commission by Mr. Muremi, who at the relevant time in 2012 was the municipal manager at Phumelele local municipality. Do you know Mr. Muremi?
Yes, I do.
Mr. Muremi, of course, in his statement deals with a telephone call he says you made to him, advising him that an Indian delegation would be coming to the farm. They were really negotiating around the release of land by the Phumelele local municipality. The issue here is, he says he called you. I know you deal with this in your statement. You dispute that. Please speak to that issue.
Thank you, Chair. I've tried to clarify myself, so I'm not entirely sure if we're talking around the same incident. But in Mr. Muremi's initial evidence, he was saying that a particular meeting was organized through the mayor. I think it was with Mr. Narayan and a lawyer. In a supplementary statement, he then says, I think I called him. What I remember is receiving the call from him, saying that he's under pressure to sign a certain agreement. And he was relatively new in the local government environment. And I said to him, I would advise, don't sign anything, especially relating to municipal land, because it's really a complex issue, without getting legal advice. Talk to the state law advisors. Phumelele is a very small municipality. It does not have its own internal legal capacity. So instead of getting a private law firm who will charge costs, who may also not have the necessary expertise to deal with matters relating to municipal land, I thought it would be the wiser thing to do to seek advice from the state law advisors. There were conversations, and that is subsequently what we did. I think he also sent me an email that I forwarded to the state law advisors, and I also spoke to Mr. Venter to say, can we please assist Phumelele, because they are in a difficult position without having internal legal capacity.
As I recall his evidence, these are two different incidents. I'm quite happy with your account of the assistance you tried to give him in relation to the lease and the advice you gave him to speak to the state law advisors. That's consistent with what he said to the Commission. But he also said to the Commission that the first time he heard about an Indian delegation coming down to Vrede to talk about the land and the farm was when he received a telephone call from you. He then rushed and made sure he got to the meeting on time. And I have understood your version to be that he is the one who called you. You did not tell him there's an Indian delegation that's coming to Vrede. Make sure you're there to talk to them.
Thanks, Chair. I have no recollection of me calling him to say there's an Indian delegation coming. The MEC was from Phumelele, he's from Vrede. the MEC would have made arrangements with the mayor, it would have been easier. It would not really make sense for them to come via me now back to Phumelela. So he may have a different recollection, but my recollection is definitely the phone call that I received from him, that he was under pressure.
And when you speak of the mayor, you're talking about Mr. John Mutaung.
Yes, that's correct.
Last question, I think, Chairman. Mr. Tabata ultimately entered into a 99-year lease agreement in respect of that Vrede land with Estina. And it was a renewable 99-year lease. Did you know anything about this before that lease was signed? Same question, when did you hear about that 99-year lease that had been signed between the department under the authority of Mr. Tabata and Estina?
I got to know about that 99-year lease agreement or the issues around the land at the time Mr. Muremi called me initially. And the state lawyers advisors had advised to say how this thing should be structured. But we did not know prior to that process. We knew in principle there's land, Phumelela is going to make available land. But the 99-year lease agreement was a separate matter, and we did have concerns just in principle about the issue of 99-year lease agreements. At that stage, I was aware, but I was aware because of Phumulela's financial position, that part of the little revenue that the municipality is able to get comes from existing lease agreements from municipal land that they were renting to farmers.
That's fine. We'll take the rest of the matter up with Mr. Tabata. I'd really just wanted to establish the extent to which you would have known that this lease was entered into with Estina, or whether you would have facilitated the entering of that particular 99-year lease with Estina. Your short answer is no.
No.
I don't know if there are any other matters that you'd like to bring to the Chairman's attention.
Not at this stage, Chair.
Chairman, those are the questions we have for this witness.
Thank you. Thank you very much. Thank you very much, Ms. Rockman, for having come to give evidence and to share what you know about the Estina project with the Commission. If there is a need to ask you to come back, the Commission will ask you to come back. But thank you very much for having come to give evidence. For now, you are excused.
Thank you very much, Chairperson, and we will continue to cooperate as we have been doing.
Thank you very much. We are going to adjourn for the day. There will be no hearing tomorrow. Next week, the former president was scheduled to appear before the Commission for the whole week. He is no longer going to appear next week. His lawyers have indicated that arising out of the judgment affecting him in the Pietermaritzburg High Court, he and the lawyers are supposed to deal with certain matters next week. So the hearing of his evidence next week has been postponed, but he is still going to appear before the Commission from the 11th of November to the 15th. He has agreed to appear before the Commission during that week, so that week stands. I will determine other dates when he will appear before the Commission other than the dates of 11 to 15 November. and at the right time, those will be made known to the public as well. As things stand, there will be no hearing next week because of this change, but should the Commission be able to make some arrangements for some witnesses to be called towards the end of the week, the public will be informed. But at this stage, there will be no hearing next week, but there will be a hearing the week after. We adjourn.